This is Bloomberg Law with June Grasso from Bloomberg Radio.
In the interest of putting this whole thing to rest, PG&E is willing to offer the Jensens $250,000 for their home.
$250,000?
In terms of land value out in Hinckley, Mr. Masery, we feel that's a more than fair price.
How about in terms of medical expenses? $250,000 isn't going to come close to what this family's going to have to spend on doctors.
Attorney Tom Girardi was catapulted into the national limelight after the 2000 Oscar-winning legal drama Erin Brockovich highlighted his role in getting a more than $300 million settlement against PG&E for poisoning a California town's drinking water. He was hailed as a pioneer of toxic tort litigation and known for extracting massive settlements for his clients.
This season on The Real Housewives of Beverly Hills.
Vegas. His fame was only enhanced as the husband bankrolling the extravagant lifestyle of the Real Housewives of Beverly Hills, Erica Girardi, whose ostentatious displays of wealth were over the top, even for a real housewife.
I'm an enigma wrapped in a riddle and cash.
But the 85-year-old man, now sitting at the defendant's table in an L.A. courtroom, is a far cry from that powerful lawyer. Girardi is now bankrupt, disbarred, living in a dementia wing of a nursing home, and on trial for stealing $15 million from his clients. Joining me is trial attorney David Ring of Taylor Ring in L.A. For people who might not know, tell us about Tom Girardi, the star lawyer, and his reputation.
Tom Girardi was a legend in Los Angeles legal circles. He's a plaintiff's trial lawyer. He represented victims of horrific accidents like plane crashes and horrible automobile accidents and things like that. And he'd been a legendary trial lawyer in Los Angeles since the 1980s. He was as big as it gets in Los Angeles. He was politically connected. He was well known to be connected with the courts and the judges, and he was a very powerful man. And so, he was untouchable. He was untouchable in Los Angeles for many, many, many years until this scandal imploded in 2020.
Tell us about the scandal that sort of opened this Pandora's box.
What caused the downfall of Tom Girardi and his law firm? It all started with a particular lawsuit, the Lion Air plane crash, which happened in Jakarta. And Tom Girardi and his firm, they would represent victims in big airplane crashes like that, even if the crash happened, halfway across the world. And that litigation was centered in Chicago in federal court. And ultimately it was settled. Boeing and some other defendants paid a lot of money. And Tom Girardi represented families who had lost loved ones in that plane crash. Now, he had a co-counsel in Chicago, a Chicago firm. And when the settlement was reached and the money was paid by the defendants, Tom Girardi's firm didn't pay his clients. One excuse after another. The firm in Chicago started to get very, very upset because clients are supposed to be paid out right away. And so this firm in Chicago went to federal court and said, there is something suspicious going on here. Tom Girardi's firm is not paying out money that they have received to the clients. And the federal court judge got very involved, went ballistic, and basically summoned Tom Girardi and others to court. And it all unfolded there because it was a house of cards. And it all fell apart at that point, and it became clear that Tom Girardi had been stealing money from clients and from his firm.
Will you explain the basics of the prosecution's case against him in the L.A. trial?
Tom Girardi is being prosecuted for wire fraud, and the wire fraud involves, 4 or 5 clients. Look, he defrauded a whole lot more than 4 or 5 clients over the years. But the U.S. Attorney's Office in Los Angeles has narrowed it down to about 4 or 5 families who basically had their funds, their settlements, stolen by Tom Girardi. So he's accused of misappropriation of client funds and wire fraud. And the amount in question in this trial is about $15 million. Again, you look at the long-term wrongdoings by Mr. Girardi, and he absconded with a whole lot more than $15 million. And the prosecution is close to resting their case, and they've put on these victims who have explained how they weren't given their settlement funds and all the excuses they were given over time. And they've also had witnesses who were the lawyers for these victims after the fact who tried to help them get the money from Girardi, when they weren't being paid. And these lawyers come in and say the excuses we got were absurd.
Is it basically like a Ponzi scheme that he allegedly operated?
I equate Tom Girardi to Bernie Madoff. The same type of personality, the same type of long-running fraud, just the absolute despicable conduct of stealing from your own clients who you have a duty of loyalty to. And so, yeah, it basically was a Ponzi scheme. What Tom Girardi apparently was doing was he spent extravagantly. We all know he is married to Erica Jane from The Real Housewives, and the amount of money that was flowing from Tom for his lifestyle and for Erica Jane's lifestyle. And so a settlement would come in. It would go into the Girardi and Keys Client Trust Fund, and Tom Girardi would take some or all of it for his own personal improper purposes, and then would lie to the client, oh, the money didn't come in yet, oh, there's a holdup, oh, it's being taxed, all sorts of stories not to pay them out. Then when another big settlement came in, okay, he might pay out the person who'd been complaining for a year or two, but now he'd stiff that client from their settlement funds. And so, yeah, basically a Ponzi scheme.
The prosecution is painting him as a celebrity attorney turned villain. But the defendant sitting there in the courtroom is this 85-year-old in mental decline. He's been diagnosed with dementia, lives in a nursing home. So might the jury feel sympathy for him or say, why are they going after him at this point?
Here's how that plays out. In this particular Los Angeles trial, the crimes that Tom Girardi is being accused of committing date back to 2010. And there's no evidence that he had any real mental decline until about 2020. So he was perfectly fit, 2010 through 2020. He was in courts, he was giving speeches, he was at politicians' fundraisers. He was in perfect mental health between 2010 and 2020 when some of these crimes were committed. And it really was only in 2020 when, yeah, he absolutely did have some sort of mental decline. And now they say he has early onset Alzheimer's or dementia. And he does not look well at all in court. But what the prosecution will do and has done is say, you can't look at this man for what he is right now here today. Look at what he's done over the past 15 years, back to 2010, when he was absolutely, positively competent.
The defense is blaming the ex-CFO, Christopher Kamen, who's charged with fraud for allegedly stealing from both client accounts and the firm's operating fund. A judge has split Girardi's trial from Kamen's, so that's quite advantageous to Girardi's defense. His lawyer can point at Kamen as the real villain here.
Yes. So Tom Girardi really has two main points in his defense. One is that, he was unfit, he was mentally declining, he had dementia, he didn't know what he was doing, he couldn't have controlled these accounts or this money because he really couldn't even handle his own day-to-day activities. So that's a big part of their defense. And the other part is what you mentioned, that the law firm Girardi and Keys had a chief financial officer named Chris Kamen, and Mr. Kamen is separately charged from Mr. Girardi for crimes that Mr. Kamen committed. And so absolutely, in this case, Tom Girardi's defense is to point the finger at Chris Kamen, the CFO, and say, you know what? He's the guy who was stealing the money. He's the guy who, wreaked havoc on the law firm's financial resources and the client trust accounts. The problem with that is that it's going to become pretty clear that the CFO, Chris Kamen, he was conducting what they've called a side fraud. He knew that Girardi was playing shenanigans with all the money. I mean, he was a CFO. He knew what was going on, and he knew he could get away with embezzling money. And so what he did, he saw this firm in disarray, knew what Girardi was doing, so he started to steal money on his own. And that's going to be a separate trial down the road against Mr. Kamen, who had fled the country and they brought him back here. But it certainly gives Tom Girardi's lawyers some arguments in this particular trial. My personal opinion, I don't think it's going to carry the day for Tom Girardi.
Apparently there is some evidence coming in on the fifth day of the trial. There was testimony about a secret bank account that was hidden from Girardi. So the defense is looking at that as evidence showing that Girardi wasn't aware of all that was going on at the firm.
Tell you what, this very, very, very interesting development in the case. this secret bank account, and we don't know a lot about it yet. It really just surfaced for the first time in the media, at least, in this lawsuit. No one had really heard about this secret bank account before. But what it appears to have been is part of perhaps Chris Kamen's side fraud, where someone set up another bank account at a different bank than the law firm routinely used, and was siphoning money over to this other bank account, and we don't really know why. We do know that checks were written out of it. We know clients were paid money out of it. But we also know that it didn't really start until close to 2019 or 2020. And so, again, you got to go back and look at the crimes that are alleged against Girardi, and those date all the way back to 2010 in this case. So, again, this secret bank account, very interesting, raises eyebrows for sure, but I don't think it's enough to get Tom Girardi off.
And there were more than 200 misconduct complaints filed against Girardi before the State Bar of California over 4 decades. Yet he managed to avoid any disciplinary action until, I think, about 2022. And the parents of a boy who died of cancer who was represented by Girardi have filed a class action lawsuit against the California State Bar, alleging gross negligence and reckless misconduct. What's your take on that case?
I think it's definitely got legs. There has been a lot that has come out against the California State Bar since this Girardi scandal erupted 4 years ago. And it's absolutely mind-numbing and despicable what has been shown. This shows you how powerful Tom Girardi was. Tom Girardi had the State Bar wrapped around his finger. Tom Girardi had so many complaints made against him over the course of 20 or 30 years. And how did he get away with that? He was the ultimate mastermind. This guy had so many connections. He actually placed an investigator in the State Bar office who was there handling complaints against Girardi. Tom Girardi was very close with some of these State Bar judges. And so the system, now that we've seen it exposed for what it was a sham. And Tom Girardi manipulated the State Bar system, and he got away with it for 30-plus years despite having hundreds of complaints made against him. And not one thing was ever done to him. Shameful.
We'll see what the jury decides in this case. Thanks so much, David. That's L.A. trial attorney David Ring. I'm June Grasso, and you're listening to Bloomberg.
Starting today, we're canceling student debt for borrowers who are enrolled in the SAVE plan and have been paying student loans for as little as 10 years.
Back in February, President Biden unveiled the SAVE plan, a student loan repayment program that ties how much someone pays each month to their income. Education Secretary Miguel Cardona said the program is targeted to certain borrowers.
These are people that took out loans of $12,000 or less, smaller loans. We know that these folks are more likely to go into default. So that's the group we targeted with this debt relief announcement.
But 8 million borrowers enrolled in SAVE have endured the chaos of conflicting up and down legal rulings on the viability of the program. That's because more than a dozen Republican-led states filed lawsuits challenging the plan in 2 jurisdictions, Kansas and Missouri. And now the Eighth Circuit Court of Appeals in Missouri has issued an extraordinary sweeping order blocking the program everywhere while litigation proceeds. This conflicts with a decision from the 10th Circuit in Colorado. On Tuesday, the Biden administration filed an emergency petition at the Supreme Court asking the justices to reinstate the SAVE plan. Joining me is constitutional law professor Michael Dorf of Cornell Law School. Mike, is the SAVE plan different from the Biden student loan relief plan the Supreme Court threw out in July of last year?
Yes. I mean, it had some different details in terms of who was eligible and what you had to do to file. But the more important piece in terms of the legal aspect is that it relied on a different set of statutory authority.
So a 3-judge panel of the Eighth Circuit with 3 Republican appointees called the plan a vast assertion of newfound power. Tell us about their decision.
So the court had 2 issues to decide. It first needed to decide whether there was standing for the plaintiffs, which were a bunch of states that were basically led by Republicans. And there it essentially relied on the Supreme Court case because Missouri is one of the plaintiffs In the earlier case, the Supreme Court said that Missouri had standing because this corporation that Missouri had chartered to process loans, known as Mohila, could suffer legal injury, and that injury would be translated to the state. The dissenters dissented on that point in the Supreme Court, but that's sort of water under the bridge. So there was really no issue about standing for the Eighth Circuit to decide. The heart of the matter was whether this was something authorized by an act of Congress. And the Biden administration had a decent argument that if you read the literal text of the statute, it does seem to give the Secretary of Education broad discretion to, modify loans, to delay payments, including on principal. But the court said two things. First, they said, well, there are other parts of the same statutory scheme that expressly grant to the Department of Education the authority to forgive loans. And given that Congress did those expressly, it's unlikely that Congress would have intended for the Secretary of Education in this more general language to be able to forgive loans. The second thing they said was the language you quoted, which was that in the last few years, the Supreme Court, and especially Chief Justice Roberts, have relied on something that has come to be known as the major questions doctrine. And the basic idea there is that if an agency is going to be exercising power over a very large part of the economy or our social life, then you need to find authorization for the agency to do so in the express language of Congress. So it's kind of what's sometimes called a clear statement rule, although there's some debate among administrative law scholars and even by Justice Barrett questioning whether that's exactly how to understand it. But in any event, that's what the Eighth Circuit said. They said, look, this is just not the kind of thing that Congress has given you power to do. Maybe Congress could do that. Maybe Congress could do it itself, but they haven't done it.
In order to issue the injunction, did the Eighth Circuit find that there was irreparable injury to the Republican states here?
Yeah, well, so that's the interesting thing. Yes, although the core of the decision, and the court says this, is likelihood of success on the merits. Of course, it's really kind of hard to see how there's an irreparable injury to Missouri because they're going to be collecting a little bit less in interest through this entity that they've created to process loans, but that there is not irreparable injury to the millions of borrowers who now have to pay off these student loans when they thought they were going to be eligible for some forgiveness. The court doesn't say that the borrowers don't have an injury or even an irreparable injury, but the court doesn't really get to the question of balancing of the equities, which is typically the last step in one of these decisions whether to grant injunctive relief.
Republican attorneys general filed separate lawsuits over the SAVE plan, this one and one filed in Kansas. The 10th Circuit said the plan could take effect while the court battle continues. So now you have an 8th Circuit decision contrary to the 10th Circuit decision. Does this mean that the Supreme Court is going to take up the case?
Presumably, yes. What's interesting about this case and so many others the Supreme Court hears these days is there hasn't been a trial. This is on a preliminary injunction. Now, maybe you don't need a trial because it's really just a pure question of law. But it's technically what they were doing was addressing whether to keep a stay pending appeal in place or to modify it. But the bottom line of the Eighth Circuit ruling is that the program is enjoined indefinitely pending Supreme Court, reversal, or potentially, I suppose, the case could go back to the district court and somehow the district court could find the case comes out the other way. But, that would result in reversal almost immediately because here, likelihood of success on the merits means we think the merits favor the challengers, meaning the state.
The Biden administration has tried all kinds of loan forgiveness plans to get around the Supreme Court's decision. And it appears they're gearing up for another one come fall because the Education Department has emailed borrowers to let it know by August 30th if they want to opt out of any future programs. I mean, is there any point anymore for the Biden administration to keep trying? The plans just get blocked by courts.
Well, it depends on what you mean by a point, right? If the point is to actually deliver debt forgiveness to borrowers, probably not. You would think that if you want to deliver debt forgiveness through existing statutory authority for one of the federal agencies, you would start with the strongest case for doing so. And, the backups tend to have somewhat weaker arguments. Although I will say that the argument for the program that was just struck down didn't rely on the kind of emergency theory that the previous one did. So it's possible that they will eventually hit upon something that the Supreme Court and the lower federal courts accept. I just think it's not very likely.
So you think that, practically speaking, there'll be no substantial student debt relief program during the Biden administration?
Yeah, I think that's right, just given the pace of litigation, right? So you can throw a Hail Mary, you can appeal to the U.S. Supreme Court and hope that they side with the 10th Circuit rather than the 8th Circuit. But again, given how closely the 8th Circuit logic tracks the logic of the Supreme Court's own opinion in Biden against Nebraska, the earlier case, I don't think that's going to happen.
Why are the Republican states so bent, so driven to stop any kind of student loan forgiveness? Is it just because it's a Biden administration initiative, or is it some other reason?
Well, I think they've got three kinds of reasons. One is, anything you're for, I'm against. I think that there's some of that going on here. But I think a second piece is that, they're hostile to executive branch agencies doing things that Congress hasn't clearly authorized because they're hostile to the administrative state. And you saw that in the overruling of Chevron. You've seen that in the major questions doctrine. You see that in these suggestions by various conservative justices that they'd like to revitalize the so-called non-delegation doctrine. I should say that the Republicans in Congress are much more hostile to the executive doing things that aren't very clearly authorized by Congress when it's a Democratic president than they are when it's a Republican president. But that, that door swings both ways. That's just generally true. And then the third thing I'll say is that, there are, I think, legitimate policy reasons to, if not necessarily oppose student debt forgiveness, to think about the issue in a broader perspective. So it's true that people who borrowed money to go to college or even to go to grad school or professional school and now are saddled with a lot of debt find that difficult, especially if they didn't have, fixed rates, which you typically don't for these things, especially as we've been in a high interest rate environment for the last couple of years. But so do other people, right? If you borrowed money to start a business, you could be saddled with a lot of debt. If you went to a less expensive college than you might have gone to that might have given you a somewhat more prestigious degree because you didn't want to be saddled with debt and you paid for your education out of pocket, or you got loans that aren't covered by one of these relief programs, then you might say, well, I'm similarly situated to the people who are getting this relief. I should get the relief as well. And there's, of course, a revenue hit to the federal government, which means either you're going to run larger deficits or you're going to have to cut somewhere else. So it's not as though student debt forgiveness is a slam dunk on the policy side. And so I think it's quite possible that some Republicans, probably even some Democrats, think that while this may or may not have certain political impact, and it's certainly valuable to the people who get the forgiveness, and they certainly, could use it, it's not necessarily the best policy, all things considered.
The next thing we'll hear on this will probably be whether the Supreme Court decides to take the case. Thanks so much, Mike. That's Professor Michael Dorf of Cornell Law School. Now, if you're one of the borrowers enrolled in the SAVE plan, you don't have to worry about payments or interest accruing yet. The Education Department has put all loans in forbearance while the litigation continues. I'm June Grasso, and this is Bloomberg.
This is Bloomberg Law with June Grasso from Bloomberg Radio.
Robert F. Kennedy Jr.'s independent presidential campaign took a hit this week when a judge kicked him off the ballot in New York after finding that he falsely claimed a New York residence on his nominating petitions, despite the fact that he lives in California. It's a ruling that could create problems for the candidate as he faces challenges elsewhere. Following a short trial, Judge Christina Reba found that Kennedy was using a sham address on the petitions to put his name on the New York ballot. In her decision on Monday, the judge said that, quote, using a friend's address for political and voting purposes while barely stepping foot on the premises does not equate to residency under the election law. In an interview with CBS 6 in Albany, Kennedy compared his situation to that of his late father, Senator Robert F. Kennedy, when he ran in New York in 1968.
He was also, ironically, also called a carpetbagger. In other words, that he didn't really live in New York State. So 6 years later now, I'm running and I'm being told I don't live in New York State. My driver's license here, I vote in this state, my car is registered here. My law license is in this state, not California. My law office is in this state. I pay income tax in this state.
Kennedy is facing challenges in more than a half dozen states, some alleging that he falsely listed the same New York address. He's appealing the New York decision. Joining me is elections law expert Richard Brafalt, a professor at Columbia Law School. Rich, how is residency defined under New York law?
Residency means domicile, which is the place that you maintain as your home, and if you're away, you intend to return to it. New York law recognizes that people can have multiple residences. You can have a main home and a summer home and another home, but one of them has to be the place that is your primary residence. In legal terms, your domicile.
Kennedy listed as his residence a friend's house in Katona, New York, where he said he rented a bedroom. But he admitted at trial that he only spent one night there. That was about a month ago in June. There's no written lease. He only made a rent payment after a New York Post story came out. He moved with his kids and his pets, except for the Falcons and the Hawk, to California in 2014. He bought a house there. And when asked at trial if he lives in California, he said yes. I mean, what is his reason for claiming New York residency?
Oh, his reason, I think, is that his running mate is a California resident, and under the Constitution, should he win any electoral votes, the California electors cannot vote for both of them. In other words, if he somehow carried California, the California electors are prohibited by the Constitution for voting for two people from their own state. So he had to have a separate residency from his vice president.
Well, the judge said that he demonstrated a long-standing pattern of borrowing addresses to keep up the appearances of New York residency. I mean, at one point, he claimed residency at a house that his sister had sold and neither of them lived in anymore.
Apparently, he's still registered to vote in New York. He has a New York driver's license and he has some other New York connections. And in some kind of fairness, he was a New York resident for a long while and had a lot of connections to New York. But yes, as I think the judge found, for quite a long period of time recently, he's been living in California with his wife and children and pets. And California has, I think the court found, and it seems reasonable, has been his principal residence for the last several years. As the court said, you need a specific place for it to be a residence, not some general geographic area. Like he's had connections to New York, but you actually need to have, as the court says, a specific abode in New York in order for New York to be a residence, and he doesn't have one.
So some of the reasons he claims residency are he has New York State fishing and falconry licenses, a New York State driver's license and vehicle registration, a New York State voter registration, a license to practice law in New York, and he pays New York State taxes. Do any of those count toward residency?
They will all be relevant if he actually had a home in New York. I mean, again, I think if he had an actual home in New York and as well as an actual home in California, it would support his argument that New York is his primary home. But the problem is he has no home in New York at all. So, I mean, I think those would have been relevant if it was more of a contest as to whether or not New York or California was his home. He had various legal ties to New York, but the law requires that he actually have an actual physical residence in New York. And that is one thing that he does not appear to have.
And as far as the spare bedroom that he was supposedly renting out, court said, quote, the court finds Kennedy's testimony that he may return to that bedroom to reside with his wife, family members, multiple pets, and all of his personal belongings to be highly improbable, if not preposterous. I mean, when you look at his testimony and the testimony of other witnesses, it seems almost like an open and shut case.
I think that's right. I mean, in some sense, the judge's first point was how strictly or loosely do I have to interpret residence? And as she says, under New York state law, under New York Court of Appeals decisions, some election qualifications can be interpreted loosely, but these very formal, specific ones have to be interpreted strictly so that the courts are consistent from case to case. So the first thing is you really do have to show that you're a resident. And then she went through what that entails, and then there was extensive testimony from all the people who are arguably providing him a home, and it was pretty clear that his connection to the place he's claiming to be a home is extremely attenuated. As he pointed out, it's one bedroom in somebody else's house. He's only been there one night in the entire time he's had a connection to it. He wasn't paying rent until this case became a case, and then he paid it retroactively, back rent. And the home itself is under foreclosure. And as she points out, he has an entire household in California, and it just seems unlikely that if he were to return to New York, he would be returning to that one bedroom with his whole household.
He also claimed advice of counsel, that his lawyer told him this was okay.
It doesn't work. I mean, he's not being prosecuted for lying. It's just that he had to fill out a form, and he filled out the form inaccurately.
So he's appealing the decision in New York Appellate Court, and his legal team has said they're going to seek injunctive relief in federal court. And they're arguing that the U.S. Constitution's 12th Amendment governs the residency of presidential and vice presidential candidates, not state law. And they made a similar argument before the judge in New York who rejected it. What do you think of that argument?
It's kind of a red herring. I mean, yes, New York State could not require him to be a resident of New York State. That would be unconstitutional. But New York State is not doing that. New York State is simply saying, in order to get on the ballot, you have to fill out a form, and you have to fill out the form accurately. And the Supreme Court has, in the past, recognized that states can set their own rules for getting on the ballot, provided that they're reasonable rules, that they're not unduly burdensome, that they're not too hard to satisfy. You couldn't require somebody to have a humongous number of signatures in a very short period of time. That would be too burdensome. But I think a rule that simply states you have to put down your place of residence is the kind of rule that probably for most candidates is not unduly burdensome. And the court has recognized the right of the state in effect to require certain forms to be filled out in order to get on the ballot. So just to repeat, he does not have to be a New York resident, but he does have to fill out the form correctly.
Could this open him up to challenges in other states? Because apparently his campaign used the same address to gather signatures in other states.
That's an interesting question, and I would break it up into a couple of parts. So in a number of states now, he is actually on the ballot. He has been approved by the relevant decision maker, whether it's the Secretary of State of that state or possibly even by a court after litigation. So one issue in those states would be, can that be reopened once the person has actually gotten on the ballot? And that would turn on the law of that state. Second question, which would be true both in those states and in the states where the process of getting on the ballot has not been resolved, is this required on their forms, and how stringently or liberally do they apply the requirements of their forms? That would be a second question. In other words, some states might be willing to waive a mistake. New York was not. So those are really sort of two big open questions. He's on the ballot now, and I don't know the exact number, but it's around 20 states that have been resolved. And that would turn on what their rules are on reopening a question like that. And the second would be, was it required in these states to fill out this form to state a place of residence? That seems like a reasonable, kind of a normal bureaucratic requirement. And it is, I think, relevant to the 12th Amendment problem of making sure you don't have two people from the same state, which also happens to be your state. But then the question is, how stringently are they going to enforce that rule? And different state courts might have different policies on how strictly or loosely they enforce a rule like that.
Taking that into account, then, might a New York appellate court be willing to waive the mistake?
It's not out of the question. I mean, there is a tension between, making someone available to the voters, and it's not relevant to his eligibility to be elected or his seriousness as a candidate. It doesn't affect whether or not he's over 35 and a citizen. That's basically the eligibility to be president. And many states do require that you gather a certain number of signatures, that either you be nominated by your party, or that if you're running as an independent, you get a certain number of signatures, or if you're running as a new party, that your new party gets a certain number of signatures. And those are all designed to establish that the candidate is serious, not frivolous. He's presumably satisfied that. So I could imagine a court saying that a question that doesn't bear on his eligibility to serve and seriousness as a candidate might be one that we'd be willing to waive. He is running for a national office, and there is some argument that court should be less restrictive because, I mean, if he was going to be really in contention that having a rule like this to knock somebody off the ballot, that would affect a serious national candidate, sort of you don't want individual states to be doing that. So that would be one possibility. But the other would be that the court might also stick with what this lower court said is, for some things which are not that burdensome, it's best to be absolutely strict, because otherwise the chance of politics playing a role and different judges applying the same rule differently in different cases looms very large. So there was an argument from consistent application of a fairly straightforward rule that says you should enforce it, versus the argument that this does not really go to either his eligibility to serve or his seriousness as a candidate, so maybe you waive it. I mean, I could see it coming out either way.
And so what's your gut feeling about what an appellate court might do?
It's very hard to imagine that an appellate court will overturn this on the facts. But the real question is, what do you do with it? Basically, do you let it go and say, well, you know, we don't have to interpret it that strictly? Or do you do what the trial court did and say, well, you know, our precedents require strict application and he's not a resident?
This challenge was brought by 4 voters with the backing of the democratically aligned Clear Choice Action.
Right.
And the Democrats have dedicated a substantial legal and ground operation to challenging third-party candidate ballot access.
That's right, although it's interesting now, at least according to recent surveys, it's now unclear from whom Kennedy pulls more votes, Harris or Trump. So it's true. When he began, obviously, he was a Democrat. He comes from obviously an extremely distinguished and famous Democratic family. I think Democrats assumed that he was going to draw mostly Democrats. I guess recent polling surveys suggest it may be closer to 50-50 as whether he's pulling from Trump or Harris. So it's not 100% clear this is the right strategy for the Democrats, but this is the strategy they've been pursuing.
Thanks for being on the show, Rich. That's Columbia Law School professor Richard Briffault. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.